Hello everyone, welcome back to the Latinx channel. If you are new here, this is the channel where we learn about the laws of Ghana in very simple ways so that you and I will know about what the laws are and other our steps accordingly, right? So we have done a lot of videos. Please quickly go through this channel and find something for yourself. And hey, today we are talking about how the courts share properties when there is a divorce. Yes, when there is a divorce. Some people ask questions that, oh, if I made my property before I married, can the other spouse say that the property is for him or her? The law says that if you're an individual, you can make a property on your own. And so upon divorce, nobody can come and say that the property that you made before marriage is a joint property. No. So far as you can show that it was something that you made before you married this particular woman or man, it is your personal property and nobody can deny you of that property, right? Remember that the law presumes that every property you make from the day of your marriage to the day of divorce is a joint matrimonial property. Remember, I said that the law presumes, it's a presumption, that every property that you made from today, the date of your marriage, to whenever there is divorce, is a joint matrimonial property. It said that it's a presumption because you can lead evidence to rebut it, so that somebody will know that, okay, although ordinarily every property is presumed to be joint matrimonial property, this very particular one is not a joint matrimonial property. It means that if you made a property on 13th March 2023 and you married on 12 March 2022, it means from that day, every property that you made till the end of your marriage, it is presumed that that property is for both of you. Yes. Why does the law presumes that way? The law makes this presumption because the law says that even if one person used his or her cash to buy that property, the other person may have been doing something in kind or services to support the other party to make that property. Or it is possible that both parties contributed in cash, but there was no receipt or evidence to show that, oh, this person actually contributed in cash. Because of course, in marriage setting, we don't ask for receipts if you send your husband or your wife to go and buy something in your name. So that presumption is there. It means that if you have evidence to show to the court that, okay, although there is a general presumption that every property made within the marriage is a joint property, this particular one was just for me, maybe by way of gifts, maybe you got it under an inheritance, maybe you got it from a lottery, something that the other person's interest or other person's contribution cannot be measured at all. Yeah. How can you show that you contributed? The law says that you don't necessarily need to show that you have receipts or payments. No. The law said that it's possible for you to prove by other means that, I contributed. Even if you don't have receipts or your receipts are missing, you can still give oral evidence or get people to support your evidence that you actually contributed in cash. If you do not have that evidence, the law says that if you provided any kind of services, maybe you were carrying mortar, you were carrying blocks or cement, you were supervising the workers on site, or maybe you sold a part of your business, or you were the one in charge of the home as a housewife or a house husband, if there's a word like that, and you're taking care of everything in the home or some other business which is owned by both of you, and because of that, the other party obtained some money or cash or got the freedom to get money to buy the property, you can also make claims to the property that they bought in, because if you had not stayed at home to take care of the children or send the children to school, this your spouse could not have gotten the energy to do all that he did by way of acquiring the property. People ask that, oh, what if I bought the land before I married the person? Really, of course, it is just the land that you bought before you married. What if you made developments during the marriage? you started building during the marriage, or you made an improvement, a major improvement on the property during the marriage, remember that you'll be deemed, or you'll be presumed that it was both of you who actually contributed money or provided services to get that building completed. And so it will be presumed to be a joint property. Now, if the law agrees that this property is a joint property, how is it shared? The law also presumes that if you did something together, if you bought a car together, if you made a house together, it is presumed that you intended to share it equally. It is presumed, as I have already said. It means that you can lead evidence to show that, oh, this person's contribution is just 10% of it or 5% of it. If the person is relying on kind, you may say that, okay, although he's relying on his or her kind services and not actually cash, the kind cannot amount to or cannot equate the cash that I invested in. If the person is relying on some services that she provided at home, you can say that, you know what, I paid for assistance for her, or that I was also supporting her in taking care of the home. That was not her sole duty, or there were some other things that would diminish the contribution by that other spouse. If you're able to show that, the court will look at the evidence before it and say that, okay, we will do it a 50-50 or a 60-40 or 70-30, whatever the court will decide on. Remember that you cannot force your spouse to say that you give the property to your children so they should not ask for their interest. No. Properties made during the marriage are for both husband and wife. And there is no obligation on either the spouse or the wife or the husband to say that we will all give the property to their children. No. So you cannot say that, oh, we are going for divorce. Oh, the properties are for my children and that is it. Nothing else matters. No, you cannot force the woman or the man to take that. Because upon divorce, anybody can go and do whatever they want to do with their life. People usually ask that, oh, can you sign a prenup and all of that as there is in other jurisdiction. I say that, in our constitution, Article 22, gives power to the courts, the parliament, to pass laws that will help so that people will have equal access to properties which were made during the marriage. And so, in my personal opinion, it will be hard for the court to accept a prenup which is trying to go away from what the constitution is actually upholding. Yes. And so you cannot say that I'm about to marry this woman or this man and I want him to sign that every property that we will make during the marriage, I will not give her anything. No, that would be unreasonable and unheard of, because it will be bringing us back. Because the constitution was being progressive when it said that people should have equal access to properties that they made during the marriage. So please take note of that. That it will be difficult. So in my opinion, prenups will not work in Ghana. The court are yet to decide on anything like that to the best of my knowledge, but I believe and I strongly believe that it will not be in the best interest to do that. The Constitution of Ghana is the primary law in Ghana. This is the law that we have been working with currently. Because of this, there's a presumption that every property which is acquired during marriage is a joint property. It's for both the spouses, and they made it to be shared equally between them. Remember that in case you took a loan from the bank to build the property, if at the time of the divorce you have actually paid all the loan amounts and all the interest, then the other party cannot also argue that, you know what, I helped you by providing services for you at home or all of that to enable you to pay off the loan, or I provided some kind services to you, or I gave you some money. But when the loan is still unpaid at the time of divorce, and maybe a lump sum of it is unpaid, then the court can rely on it to say that, you know, after divorce you are the one who is going to pay for this loan, and so it will be unreasonable for us to take the property to be a joint property for both of you to share it equally. Yes, so please take note of that. I know there are questions because, of course, the matrimonial properties and divorce and joint acquired properties is a broad topic. I'll leave this here. If you have a question, peculiar issue, please drop it in the comment box. I'm willing to answer you in the comment section. And please share with your friends, share with your family. Let us all learn together. And if there are any topics that you want me to discuss, hey, feel free and let me know about it. Until we meet again, please take care of yourself and be kind and keep loving. Bye.